Welcome back to the Deep Dive. Today we're tackling a really fascinating topic, one that forms the absolute legal foundation of the corporate world. How a company is legally born and the critical documents that define its entire life.
That's right. We are diving into Chapter 2 of the foundational law governing corporations, the rules around incorporation, and, everything that comes along with it.
And our mission today is to conduct a deep, practical breakdown of this process. We want to walk you through the legal tripwires and safeguards embedded in this law.
Exactly. So that by the end, you don't just know the rules, but you understand the consequences of breaking them. From the moment a single person has an idea, right up to the severe penalties the tribunal can impose.
Okay, let's unpack this. We're translating complex mandates into clear, usable knowledge, explaining the why and how behind core legal concepts like the charter documents, the memorandum, and the articles, and those powerful, sometimes contradictory legal concepts of ultra-virus and indoor management. We're going to start at the very beginning with the creator of the company, the promoter.
Let's do it.
So when most people think of a promoter, they imagine the person who has that initial spark of genius, the founder. But legally, the definition is far less romantic. It's much more rooted in liability.
It is. The law is targeting accountability. The definition is fundamentally liability-focused, aiming squarely to identify who can be held responsible for fraud, misstatement, or breaches of trust during that critical formation stage.
So it's not about inspiration.
Not at all. It's about responsibility.
Which means the law casts a deliberately wide net. So how does it catch individuals who might be, pulling the strings behind the scenes without an official title?
Precisely. That's the key. The law defines a promoter as a person who meets any of three primary tests. First, they are named as a promoter in the company's prospectus, or they're identified in the company's annual return. That's the easy one, the formal recognition.
Okay, that seems straightforward. But what about that informal influence?
Right, that's the critical part. The second test targets control. The person must have control over the affairs of the company. And this control can be direct or indirect, exerted as a shareholder, a director, or just as a powerful figure influencing the decisions.
I see.
And the third test really confirms this influence. It states a person is a promoter if the board of directors is accustomed to act in accordance with their advice, directions, or instructions.
Wow, that phrase, accustomed to act, that sounds really powerful. So if a major investor who's neither a director nor a shareholder is dictating the board's strategy, are they now legally exposed as a promoter?
Absolutely. If their influence shapes the foundation and the management of the company, the law will hold them accountable. This is all intended to stop bad actors from hiding behind layers of corporate structure.
Okay, but what if you're, say, the lawyer drafting the documents or the engineer advising on the plant design? You're often giving advice the board is accustomed to taking. Does the law just pull in every professional consultant?
No, and that's a really crucial exclusion embedded right in the definition. It specifically exempts professionals, attorneys, technical or functional experts who are acting merely in a professional capacity.
Yeah.
Their role is to provide a service, not to, undertake the formation or exert that foundational control over the business project itself.
So the distinctions between advising on how to set up the company legally versus undertaking the action to make it a company.
That's the essence of it, yes.
Yeah.
And the courts have clarified this. In the classic case of Whaley Bridge Printing v. Green, a promoter was defined as anyone who undertakes to form a company and who takes the necessary steps to accomplish that purpose. They are the operational force.
I often hear that promoters stand in a fiduciary position. What does that legal term actually mean for someone setting up a company?
Fiduciary means a position of trust and confidence. So, since the promoter is bringing the corporate entity into existence, they can't, for example, secretly profit from sales of property to the company without full disclosure. They owe a duty of utmost good faith to the company they're creating and to the future shareholders. That is completely non-negotiable.
And their involvement doesn't necessarily have to start on day one, does it?
No, not at all. We need to dismiss that assumption. Judicial interpretation confirms that a person who joins later, perhaps to arrange the floating of capital or advise the board on an IPO, unless they are purely professional advisors, they will also be regarded as a promoter if they're taking those necessary steps.
Okay, so once the promoter has the project underway, the next step is the legal birth, covered under the modes of incorporation. Today, formation is a creature of statute.
Yes, Section 3 dictates the minimum human input required to start the engine of incorporation. The numbers are rigid. A public company requires 7 or more persons. A private company, 2 or more persons. And the most revolutionary change in recent times, the one-person company, or OPC, may be formed by just one person.
That OPC status is key. We'll definitely dive into that next. But first, the fundamental appeal of the corporate form is limited liability. How does the Act categorize liability?
So, Section 3 outlines the 3 fundamental ways members can limit their risk. Companies can be incorporated as limited by shares, limited by guarantee,
Right.
or as an unlimited liability company, which is pretty rare today, but still permitted. It's also possible to have a company limited by both guarantee and shares.
Why would anyone choose unlimited liability in the modern era?
Well, generally it's for highly specialized partnerships or structures where the members want maximum credibility with, specific high-value creditors. But for the vast majority of commercial ventures, limited by shares is the default. Your liability is capped at the unpaid face value of your shares.
Now, you mentioned IFSC companies, those operating in international financial services centers like Gujarat Gift City. Do they have special constraints on their liability structure?
They do, and it's a very strict constraint. Specified IFSC public or private companies must be formed only as a company limited by shares. No guarantee, no unlimited liability allowed. It just reflects the very targeted, regulated environment they operate in.
Got it. Okay, so let's get into the weeds on the OPC, the one-person company. This is a huge modern shift. It means a single person can enjoy the protection of limited liability without needing a partner.
It solved a huge problem for small entrepreneurs, but the eligibility rules are quite restrictive and they're designed to ensure domestic involvement and maturity. The sole member must be a natural person, so not a company.
Not a corporate entity?
Exactly, they cannot be a minor. And crucially, they must be an Indian citizen. This applies regardless of whether they are resident in India or not.
That residency distinction is critical for the Indian diaspora. So how exactly is resident in India defined for this purpose?
A resident in India is a person who stayed in India for not less than 120 days during the immediately preceding financial year. But the key is citizenship. An Indian citizen who is a non-resident Indian can still absolutely form an OPC. The primary bar is citizenship, not residency.
Are there any types of business the law believes are just too complex or sensitive for a single-member structure?
Yes, there are 2 definitive exclusions. First, an OPC cannot be incorporated or converted into a Section 8 company. That's the not-for-profit structure.
Okay.
Second, and this is a major constraint, an OPC cannot carry out non-banking financial investment activities. This restriction explicitly includes investing in the securities of any other corporate body. It's really intended for straightforward trading or service businesses.
So not for complex financial stuff.
Right. Not for asset management or anything like that.
Since the OPC is inherently fragile, one person holds all the power, the law must require a backstop to ensure perpetual succession, that essential quality of a company surviving its owner. And that backstop is the nominee.
The nominee is, I like that, the price of perpetual succession in a single-person structure. The company's memorandum of association must indicate the name of a nominee, who also has to be a natural person, an Indian citizen, and not a minor, and it has to include that person's prior written consent.
What's the specific legal function of that consent? Why is it so important?
The consent ensures that the succession is immediate and automatic. If the sole member dies or becomes incapacitated, say they're declared insolvent and legally incompetent to contract, the nominee instantly steps in as the new member.
So it prevents the company from just collapsing.
It prevents the company from collapsing due to the sole member's absence. So if Ms. Madhu, the sole member, becomes incapacitated, the nominee, Mr. Sudan, automatically becomes the new legal personality steering the company. The company's legal existence is preserved.
That's a non-negotiable continuity.
Exactly. When you incorporate the company through the Spice Plus system, the nominee's consent must be filed right then and there.
Now, to prevent one individual from controlling, an empire of single-person companies and abusing the limited liability protection, the law must limit involvement.
It does so very strictly. A natural person has a cap. They cannot be a member of more than one OPC, and they cannot be a nominee of more than one OPC at any point in time. It's a single bite at the apple, both as an owner and as an inheritor.
But what happens in those complicated situations, like a death, where a person who is already a member of OPC-A suddenly inherits membership of OPC-B because they were the nominee?
That's where the 180-day grace period kicks in. If a person finds themselves in noncompliance, a member of 2 OPCs due to succession, They have a pretty substantial window of 180 days to regularize their position.
So they have to choose one.
They have to choose which company to retain or, wind up the surplus one.
What if the nominee simply decides they don't want the risk or responsibility anymore?
The nominee has the right to withdraw their consent. They give written notice to both the sole member and the OPC itself, and the clock starts ticking immediately. The sole member must nominate a replacement within 15 days of receiving that notice.
Or if the sole member, let's call him Rajesh, wants to replace his nominee Rupali because she's ill, he can do that unilaterally, provided he gets consent from the new nominee Ramnivas.
He absolutely can, at any time, for any reason. But notice the constraint in that example. He cannot nominate his minor son, Rakshak. The nominee has to meet all the same eligibility requirements as the sole member.
And the regulatory consequence of any of these changes, withdrawal, replacement, cessation, it's just a filing, right? It's not some monumental change to the company's foundational document.
Correct. The company must file notice of the change with the registrar within 30 days. And crucially, even though the nominee's name is listed in the Memorandum of Association, a change in nominee is not legally deemed an alteration of the memorandum. It's an administrative update, not a constitutional amendment.
Got it. Since the OKC is intended for the single entrepreneur, the law must have stripped away some of the enormous compliance burdens that afflict larger companies. What special privileges do they enjoy?
They have some significant exemptions, designed to reduce bureaucracy. For instance, in financial reporting, they aren't required to prepare a cash flow statement as part of their financials.
And what about governance? The meeting requirements for a public company can be paralyzing.
Their governance is vastly simplified. The annual return can be signed solely by the director, without needing a company secretary. And the single most burdensome requirement for most companies, the annual general meeting, is not necessary for an OPC.
Wow, so a lot of the general meeting rules just don't apply.
They just don't apply. And for board oversight, the requirement is minimal. The board needs to hold only one meeting in each half of a calendar year, separated by at least 90 days. That's a huge relaxation.
And the deadlines for filing their financial statements.
They get a major extension. They are allowed 6 months from the close of the financial year to file their financial statements, whereas many other companies have a standard deadline of 30 days after their AGM. It just acknowledges the limited resources of a one-person operation.
Okay, now let's swing back to public and private companies. The law dictates minimum headcount. 7 for public, 2 for private. What happens if a company fails to maintain that minimum number?
This is Section 3A, and it is the ultimate legal tripwire, because it threatens to remove the single most valuable corporate protection, limited liability. Members become severally liable for debts, but only if 2 severe conditions are met.
Okay, tell me the 2 conditions that strip away that protection.
First, the number of members has to remain below the legal minimum for a prolonged period, more than 6 months. The law gives a generous grace period to fix the issue.
And the second?
Second, and crucially, the person carrying on business after those 6 months must be cognizant or knowingly aware of the reduced membership count.
So it's not the initial failure that triggers the penalty, but the knowing continuation of business while non-compliant.
Absolutely. The law's purpose here is to penalize members who knowingly abuse the structure. The consequence is devastating. Such members become severally liable for the payment of the whole debts contracted during that time.
During that time?
Yes, meaning any debt incurred after the 6-month grace period expired.
Let's use your example. Harmony Limited, public company, drops to 6 members in August. They take a large loan in March of the following year, aware they are non-compliant. If they default, the creditor can sue Anthony, one of the remaining 6 members, individually for the entire loan amount, even though it's a limited company.
That is correct. Anthony and the other 5 members lose the protection of limited liability for that specific debt contracted after the 6-month window closed. It's a powerful incentive for compliance and a critical protection for creditors.
The journey to incorporation, once a mountain of paperwork, is now highly streamlined through integrated web forms. Tell us about the modern system.
The modern procedure relies heavily on the SPICE Plus system simplified pro forma for incorporating company electronically plus. It's an integrated web form that provides up to 10 services from various government departments, MCA, labor, revenue, all in one place.
That's the government's push for ease of doing business.
Exactly. But the documentation required from the subscribers, the people agreeing to take the first shares, is staggering. The law demands integrity because fraud at the inception is the hardest to undo later. Key requirements include that every subscriber must sign the foundational documents in the presence of a witness who must also attest the signature and provide their full particulars.
And what if the subscriber is an entity, like an LLP or another company?
If the subscriber is a corporate body, the documents have to be signed by a duly authorized director or officer backed by a proper board resolution. If it's an LLP, it's an authorized partner.
Wait, can the director who signs on behalf of Company A also be a subscriber in his individual capacity?
No, and that's a crucial legal block. The authorized person signing for a corporate subscriber cannot simultaneously be a subscriber in their individual capacity. This prevents dual roles and potential conflicts of interest at the foundational level.
And for foreign subscribers, how does the law ensure their signatures are legitimate?
This is complex because we rely on international legal standards. If they are outside India, their signature and address proof must be notarized by a notary public. And if they live in a country that's not part of the Commonwealth or the Hague Apostille Convention, the notary certificate has to undergo further authentication by a diplomatic or consular officer.
A multi-layered official authentication.
Right, to ensure those foreign documents are valid.
The filing process isn't just about documents, it's about solemn declarations to ensure the first directors and subscribers are in good standing.
The declaration is a crucial legal promise from every subscriber and first director. They must declare that all information filed is correct, complete, and true. More importantly, they have to swear that they haven't been convicted of any offense related to the promotion or management of any company.
Right.
And they haven't been found guilty of fraud, misfeasance, or breach of duty in any company during the last 5 years.
That declaration is essentially a filter to prevent corporate bad actors from starting new ventures.
Precisely. Furthermore, the first directors must submit their identity details, their DIN, nationality, proof of identity, and crucially, their consent to act as a director.
And the level of detail required for the subscriber's personal information seems extraordinary.
It is. It's an extraordinary level of detail designed for fraud prevention. It includes a recent photograph, parent's name, nationality, date and place of birth, educational qualification, occupation, PAN, email, phone, and detailed address proof. The residential proof, like a bank statement, can't be more than 2 months old.
The law wants to know exactly who you are, right up to the moment of incorporation.
Right.
Once the registrar is satisfied, the company receives its birth certificate, the certificate of incorporation. What does this document legally accomplish?
The COI establishes the company as a separate legal entity. It grants it perpetual succession and the capacity to function, to exercise all corporate functions, acquire property, enter into contracts, sue, or be sued. It is the company's moment of legal birth.
Now, it used to be that this certificate was conclusive proof that everything before it was legitimate. Has that changed?
That is a major change in the modern legal framework. Under the 2013 Act, the Certificate of Incorporation is not conclusive proof that everything filed beforehand was accurate or in order. This change exists specifically because the law now gives the National Company Law Tribunal, the NCLT, massive post-incorporation powers to intervene if fraud is discovered later.
And what about the CIN? That 21-digit number is the company's unique signature.
The Corporate Identity Number, or CIN, is allotted by the registrar. It's a unique 21-digit alphanumeric identifier that acts as the company's DNA. You can decode crucial details from it. Take Infosys. The first letter tells you the listing status, the next 5 digits the industry code, then the state, year of incorporation, classification, and finally the registration number.
It's a public informative identifier.
Yes.
Which brings us to the ultimate sanction. If all that stringent documentation was based on a lie, what are the penalties?
The penalties are swift and severe, leveraging the powerful fraud provision, Section 447. If any person, promoter, first director, declarant furnishes false information or suppresses material facts during registration, they are liable for action for fraud. That's a serious criminal liability.
But let's look at the NCLT's power after the company has already started trading. The company is operational, jobs are created, contracts are signed, and then the fraud is discovered. What can the tribunal do?
The NCLT has enormous power here because the company's very existence is based on a lie. The tribunal can pass 4 severe types of orders.
Give me the most dramatic one first.
The tribunal can direct that the liability of members shall be unlimited.
Wait, unlimited liability. That is the entire reason a person forms a company.
Yeah.
To have the NCLT remove that shield post-incorporation that shows the law's zero tolerance for foundational fraud.
Absolutely. Beyond that, the NCLT can also regulate the company management, making changes to the MOA or AOA to protect the public interest. They can also direct the removal of the company's name from the register or order the winding up of the company.
But the NCLT can't just act unilaterally, right? There has to be due process.
No, of course. Before issuing any such order, the company must be given a reasonable opportunity of being heard, and the tribunal is mandated to take into consideration the existing transactions, obligations, and liabilities the company has incurred. They are balancing the need for justice against the need to protect innocent third parties.
Okay, let's move away from profit and talk about Section 8, the path for organizations that prioritize social, charitable, or developmental objects, the not-for-profit companies.
These entities are still companies, but they operate under a special license granted by the government, often delegated to the registrar. And to get that license, they have to satisfy three criteria centered around mission and finance.
What are those three criteria?
First, their objects must promote public good: commerce, art, science, sports, education, and so on. Second, they must intend to apply any profits they earn only toward promoting those objects. And third, they must explicitly intend to prohibit the payment of any dividend to their members. The non-distribution of profit is the defining feature.
Can a firm, which is often an association of individuals, be a member of a Section 8 company?
Interestingly, yes, a firm may be a member. However, certain entities cannot become Section 8 companies. Neither an OPC nor a small company can be incorporated or converted into a Section 8 structure.
Beyond the standard MOA and AOA, what extra assurances does the government require for this license application?
Since they're dealing with public good, the requirements are higher. The application must include a declaration from a professional, a lawyer, CA or CS, confirming that the incorporation documents comply with the Act. And most crucially, they have to provide a detailed estimate of the future annual income and expenditure for the next 3 years.
To justify their plans.
Yes, justifying the sources of income and the specific objects of expenditure.
Because their mission is regulated by a license, changing the constitutional documents must be much harder than for a regular commercial company.
Substantially harder. Any alteration to the Memorandum of Association, the company's core purpose, requires the prior permission of the central government. Altering the Articles of Association requires prior permission from the ROCs. They cannot unilaterally change their mission.
What if the company decides it needs to stop being charitable and convert into a normal commercial entity?
This is a really rigorous process designed to protect public assets. It requires a special resolution, a detailed explanatory statement, and filing the application with the regional director.
And who must they inform?
They have to serve notice to anyone who has a stake in their charitable funds: the Chief Commissioner of Income Tax, the Charity Commissioner, and the Chief Secretary of the State. These authorities get 60 days to make representations.
And they have to go public with it.
They do. They have to publish a public notice in both a vernacular and an English newspaper, ensuring broad public awareness of the intended conversion.
This high degree of public scrutiny seems designed to confirm that no public funds are being improperly privatized.
Exactly. They must also confirm they've filed all their financials and annual returns up to the preceding financial year before even applying.
And what triggers the revocation of the Section 8 license itself?
The license can be revoked if the company acts fraudulently, contravenes the requirements, or conducts its affairs prejudicially to the public interest. If it's revoked, the registrar must immediately add limited or private limited back to the company's name, stripping away that special privilege.
If the government decides the revocation is necessary to the public interest, what happens to the remaining assets?
This is a major safeguard. If the company is wound up, any surplus assets remaining after all debts are paid cannot be distributed to members. They have to be transferred to another Section 8 company with similar objects, or they're credited to the Insolvency and Bankruptcy Fund.
The penalties here are dramatic. Up to 1 crore rupees for the company and up to 25 lakh rupees for the officers. This signals how seriously that charitable mandate is viewed.
It reflects the high standard of trust placed in these entities. And if fraud is involved, the officers face liability under the most severe provision, Section 447.
Okay, we've talked a lot about the constitutional documents. Let's really focus on the Memorandum of Association. It's the ultimate document. It defines the company's relationship with the outside world, its charter. What is it primarily designed to achieve for an outside creditor or investor?
Its primary design function is disclosure and limitation. It enables any outside party, a creditor, a supplier, a potential investor, to know the exact scope of the company's powers and its field of operation. It sets the boundaries.
And what are the 6 foundational clauses the law mandates?
The MOA must contain the name clause, the situation clause, which is the registered office location, the object clause, its purpose, the liability clause, the capital clause, if applicable, and the subscription clause. And for the OPC, that specific nomination clause we talked about.
Let's start with the name.
Mhm.
What are the mandatory liability suffixes that immediately tell the public what kind of entity they're dealing with?
Public companies must append the word limited to their name, and private companies must use private limited. This is the instant public signal regarding the limits of member liability.
How does a promoter ensure their brilliant new name isn't already taken?
They apply for name reservation through the Spice Plus system. For a proposed new company, that name is reserved for a short period of 20 days to allow time for the incorporation filing. If an existing company is changing its name, the reservation, made via the RUN web service, lasts for a more generous period of 60 days.
What happens if they need more time before the full incorporation paperwork is ready?
Extensions are possible, typically extending that 20-day reservation up to a maximum of 60 days in total, but it's subject to increasing reservation fees. The key is preventing the name from lapsing and being scooped up by someone else.
Which names are absolutely off limits?
Well, names that are identical or too closely resemble an existing company are prohibited. And crucially, the government restricts names that suggest a connection or patronage with the central or state government, or include politically significant words like national, union, board, authority, prime minister, and so on, unless they get prior approval.
You mentioned what constitutes resemblance goes beyond simple similarity. Can you clarify that?
Yes, the rules are very specific because corporate names are vital assets. Resemblance includes trivial differences like changing from plural to singular, adding punctuation, so ABC Ltd is the same as ADC Ltd, using different verb tenses, slight spelling variations,
Even adding a domain extension.
even adding a domain extension like .com or .net to an existing name, or if you take an existing name and just add a geographical location to it, like Salvage Technologies Delhi Ltd, when Salvage Technologies Ltd already exists, that counts as resembling it.
If someone managed to reserve a name using fraudulent information, what's the penalty?
If the name was reserved improperly and the company hasn't been incorporated yet, the name is canceled, and the applicant faces a penalty up to 1 lakh rupees. If the company is already incorporated, the registrar can initiate action, including compelling a name change, but they have to give the company a chance to respond first.
So once a company has its name, the next most important external reality is where it lives. The situation clause. What does this establish?
The situation clause names the specific state where the registered office is located. This is the company's legal domicile, which determines its nationality and dictates jurisdiction for virtually all legal and compliance purposes, which registrar governs it, which tribunal hears its cases, and where its statutory books must be kept.
And the company must establish this physical location quickly.
Yes, the company must establish a registered office capable of receiving communications within 30 days of incorporation. It can't just be a P.O. box.
Now, the object clause defines the company's universe of possible actions. Why is defining this universe so crucial?
It's the legal mission statement. It states the specific objects for which the company is incorporated and everything necessary to pursue them. And this clause is the ultimate boundary because it leads directly to the doctrine of ultravirus.
This is where the MOA's power truly manifests, the doctrine of ultravirus, meaning beyond powers. Explain why this is so terrifyingly final in corporate law.
The doctrine is final because it dictates that a company cannot act beyond the objects defined in its MOA. Any act that is ultravirus the MOA is void from the very beginning. It's legally null. The terror is that this action cannot be ratified or made valid, even if every single shareholder votes to approve it later.
How does that differ from a director acting without the board's permission?
That's the critical distinction. An act ultravires the director, they lacked the internal authority, or ultravires the articles, they broke an internal rule, can often be ratified by the shareholders, provided the action still falls within the company's broad powers defined in the MOA.
But not if it's ultravires the MOA.
Right. If the act is ultravires the MOA, the company fundamentally lacked the legal capacity to do it in the first place.
In the 1870s, there was a dramatic case involving a Belgian railway contract that defined corporate law forever. Tell us the story of Ashbury Railway Carriage and Iron Co. Ltd. v. Rish.
The Ashbury Company was formed to deal in railway plans and act as general contractors. They signed a contract to finance and construct a railway line in Belgium. The court looked at the MOA and determined that financing a Belgian railway was outside the scope of mechanical engineers and general contractors. The contract was declared null and void.
And the shareholders couldn't fix it.
The House of Lords emphasized that the contract was prohibited by the company's constitutional limits, and therefore no shareholder resolution could make it valid. It was void forever.
So the doctrine protects shareholders by ensuring their money is only used for the stated purposes, and it protects creditors by ensuring assets aren't gambled away on unrelated ventures.
Precisely. It keeps the company confined to the box defined at its birth. The only way to engage in a new type of business is to formally alter the MOA prospectively. A mistake in the past remains void.
Let's quickly detail the final 3 mandatory clauses of the MOA.
The liability clause defines the member's limit of exposure. For limited by shares, it's capped at the unpaid amount on the shares. For guarantee companies, it specifies the amount each member undertakes to contribute specifically upon winding up.
The capital clause is straightforward, defining the maximum capital the company is authorized to raise.
Yes, the capital clause states the maximum authorized capital, its division into fixed value shares, and the minimum number of shares, at least one the initial members agree to take.
And finally, the subscription clause lists those initial members and how many shares they are taking to officially start the company.
It lists the name of each subscriber and explicitly commits them to the number of shares they agree to take. This is the public commitment that gets the company started.
So if the MOA is the external charter governing the company's powers against the world, the Articles of Association are the comprehensive rule book governing the company's internal affairs and day-to-day management.
That's the critical contrast. The AOA contains the practical rules, how meetings are called, how shares are transferred, how directors are appointed. It complements the MOA, but it is subordinate to both the MOA and the Companies Act. The AOA is the internal operating manual.
And these articles create a contract not just between the members and the company, but between the members themselves.
Absolutely. The AOA establishes a binding contract. A classic example is Borland's Trustee v. Steel Bros & Co. Ltd., where the article stated that if a member went bankrupt, their shares would be sold at a price fixed by the directors. Even the bankrupt member's trustee was bound by that clause because it was an inherent condition of owning those shares.
And the law provides model forms for the AOA so companies don't have to draft everything from scratch.
Yes, the Act provides model forms depending on the company type, which can be adopted wholly or partially.
This is where internal rules can be made harder to change than standard law requires. The powerful concept of entrenchment. Why would a company want to make its own rules harder to change?
Entrenchment is a strategic legal tool. It's often used to protect specific, highly sensitive internal policies or to protect minority shareholder rights. It allows the company to dictate that altering certain articles requires a higher majority than the standard special resolution of 75%.
Like a 90% majority.
Exactly. For instance, a private company might require a 90% majority to change its rules on share transfers.
When must this entrenchment provision be established?
It can only be included in one of two ways, either right at the formation of the company or later by an amendment. If amending a private company's articles, the change requires the agreement of all members. For a public company, it requires a special resolution, and the company must notify the registrar of this entrenchment.
It seems like a way for founders or initial investors to bake in permanent protection for their core principles.
That is precisely the point. It gives a provision a kind of constitutional weight that makes it extremely difficult to override down the line.
We've established the hierarchy. MOA is superior to AOA. But both are absolutely subordinate to the Companies Act itself.
That is the supremacy rule established by Section 6. The provisions of the Companies Act have an overriding effect over anything contained in the MOA, AOA, any agreement, or any resolution. Any conflicting provision in those documents is instantly void.
Can you provide a clear example of that statutory supremacy?
Sure. The Act is very clear that dividends can only be paid out of profits. If a company's Articles of Association tried to allow the payment of dividends out of share capital, that specific provision in the AOA would be void because it conflicts with the Act. The Act always wins.
Is there ever a saving grace, a situation where the internal documents can prevail?
Yes. Section 6 begins with the phrase, save as otherwise. This means if the Act explicitly states that the article shall prevail on a specific matter, then the internal rule takes precedence. This is the rare exception, such as in certain provisions governing the voting power of members in private companies, where the AOA is given explicit latitude.
Now let's look at the flip side. How the law protects the company from outsiders who claim ignorance of its rules. This leads us to the doctrine of constructive notice.
Since the MOA and AOA are public documents filed with the registrar, the law deems every person dealing with the company to be aware of their contents. Whether you actually read them or not is irrelevant. You are assumed to know the scope of the company's powers. This is the company's defensive shield.
How rigid is this doctrine in practice?
It's historically very rigid. An outsider cannot claim relief by pleading ignorance of a rule embedded in the company's charter. If a vendor accepts a massive check signed by only one director, and the articles require 2 signatures for amounts over a certain threshold, the vendor cannot claim payment.
Why not?
Because they had constructive notice of the internal rule, even if they never saw the document.
That sounds incredibly harsh for the day-to-day conduct of business. I mean, if every vendor had to read every article of every company they dealt with, business would just grind to a halt.
That criticism that the doctrine is unreal in the face of business reality is exactly why the courts developed a necessary counter-doctrine to mitigate its harshness.
This is where practical business efficiency steps in. The doctrine of indoor management, or Turquoine's rule, which acts as the primary exception to constructive notice, protecting honest outsiders.
Right. The essence is simple. People dealing with the company are entitled to presume that all necessary internal proceedings and formalities, the things that happen behind closed doors, have been duly and properly carried out.
Tell us the story of Royal British Bank v. Turquoine.
In that classic 1856 case, the company's articles required that for the directors to borrow money on a bond, they needed a prior resolution from the shareholders. The directors borrowed money from the bank without securing this internal resolution. The court ruled that the bank was entitled to assume that the internal resolution had been duly passed. The internal flaw was the company's problem, not the bank's.
The company was held liable.
It was. This rule is essential for commercial trust. If outsiders constantly had to verify every internal signature, resolution, or meeting minute, commerce would be impossible.
So the outsider is usually protected by Turquoine's rule, but when does that protection break down? When does the harshness of constructive notice snap back into effect?
The protection is revoked in 5 key circumstances, essentially when the outsider is not acting in good faith or is negligent. First, if the outsider has actual knowledge of irregularity.
Okay, if they know about it.
Right. Second, negligence. If the irregularity was suspicious enough to invite a proper inquiry, and the outsider failed to make that inquiry. Third, forgery. This is absolute. The rule does not apply to forged documents. Nothing can validate a forgery.
In the last 2.
Fourth, where the core question is whether the person acting had the agency existence to represent the company at all. And fifth, the most important for our discussion today. The act is ultra vires the company. If the action is beyond the limits of the MOA, the doctrine of indoor management cannot save the contract.
Because the outside party is constructively deemed to know the limits of the MOA in the first place.
Exactly.
So these doctrines show us that the MOA is essentially untouchable in terms of past actions. But what if the company realizes its business needs change? Altering this foundation is the next big challenge. What's the standard requirement?
Altering the MOA addition, omission, or substitution generally requires a special resolution from the shareholders and subsequent registration with the registrar.
Let's look at the change of name. What restrictions apply?
A name change requires a special resolution and ROC approval. But critically, the change is strictly prohibited if the company has any unpaid statutory filings, annual returns, or financial statements, or if it has defaulted on the repayment of mature deposits or debentures. The company has to be clean.
And when is the name change legally effective?
Not until the registrar issues a fresh certificate of incorporation with the new name. That fresh certificate validates the constitutional change.
What if a company successfully gets a name, but it later turns out to be identical to a registered trademark?
This is rectification of name under Section 16, and it's a major point for brand protection. The central government can direct a company to change its name if it too closely resembles an existing name or, critically, a registered trademark.
There is a vital time limit for the trademark owner to make this objection, isn't there?
Yes. This is the crucial cutoff. A registered trademark proprietor must make their application for rectification within 3 years of the company's incorporation or name change. If they file after that 3-year window, the company cannot be compelled to change its name.
Moving the registered office between states is perhaps the highest stakes alteration, as it changes the company's domicile, jurisdiction, and relationship with creditors.
This requires the highest level of approval, a special resolution and approval from the central government. The process is lengthy because the rights of creditors are paramount. The company has to advertise the application in both vernacular and English newspapers, giving creditors public notice.
And the government has to be satisfied.
The regional director must be satisfied that all creditors and debenture holders have consented, or that the company has made sufficient provision or provided adequate security for the due discharge of all debts.
It's a thorough investigation to ensure the move doesn't allow the company to escape its financial responsibility.
Exactly. Once approved, the order must be filed with the registrars of both the old and the new states. The registrar of the new state then issues a fresh certificate of incorporation, formally acknowledging the change in domicile.
We established that the object clause is sacred. But if a company raised money from the public through a prospectus and has unutilized funds, changing that object becomes an even higher hurdle.
It requires a special resolution passed via postal ballot, which is necessary for broad, remote shareholder consent. This is because public money was raised for a specific purpose, and changing that purpose requires maximum transparency.
What must be disclosed in the notice for this postal ballot?
The notice must be extraordinarily detailed, listing the total money received, the precise unutilized amount, the full justification for the alteration, and the estimated financial impact. And the company must also give the dissenting shareholders, those who vote against the change, an opportunity to exit.
Meaning the promoters have to buy them out.
Promoters and controlling shareholders have to buy them out as per market regulations.
Altering the AOA, the internal rules, requires a simple special resolution. But if that alteration changes the company from public to private, it again requires government approval.
Yes, the conversion of a public company into a private company is only valid if approved by the regional director, and the application must be made within 60 days of passing the special resolution. This is to ensure the conversion doesn't improperly strip shareholders of rights.
And finally, the administrative task of updating every copy of the documents.
This is mandatory under Section 15. Every alteration made in the MOA and AOA must be noted in every copy, electronic or physical. The penalty for default is clear: a fine of 1,000 part for every copy issued without noting the alteration.
Let's turn to the practical reality of the company's address. The registered office is the company's legal contact point, and it must be established fast.
A company must have a registered office capable of receiving communications within 30 days of incorporation. It must be a verifiable physical location. Verification of this office must be furnished to the registrar within that same 30-day period.
The physical labeling of the office seems surprisingly detailed in the act.
It's designed for maximum transparency. The company's name and address must be painted or affixed conspicuously outside every office or business location. And if the local language is different from the language used in the name, it must also be displayed in the local vernacular.
And if the company has recently changed its name.
If the name has changed within the last 2 years, both the old and new names must be displayed. And for OPCs, they must conspicuously mention one-person company in brackets below their name wherever it's displayed.
We know moving states is difficult, but even moving within the same state can require major approvals depending on the distance.
It depends on the administrative boundaries. Moving within the same city only requires a board resolution. Moving outside the local city limits, but staying within the same registrar's jurisdiction, requires a special resolution. And moving from one ROC jurisdiction to another within the same state requires a special resolution and deconfirmation from the regional director.
And if the registrar suspects the company is simply a ghost entity that doesn't operate from that address.
The registrar has the power to initiate a physical verification. If the company is found to be non-compliant or dormant, the registrar can initiate action to remove the company's name from the register.
Striking them off.
Essentially, yes.
Getting the certificate of incorporation is only the beginning. For a company with share capital, there is a final post-incorporation hurdle before business can actually start.
This is Section 10A, introduced by the 2019 amendment. A company with share capital can only commence business or exercise borrowing powers if 2 critical conditions are met after incorporation. First, verification of the registered office must be filed. Second, the directors must file a declaration stating that every subscriber to the MOA has paid the full value of the shares they agreed to take.
Why is that payment declaration so important?
It ensures the company has its foundational capital paid up. A company can't start borrowing money until its basic capitalization commitment is fulfilled. And if any of the objects require sectoral regulatory approval, like from RBI or SEBI, that approval must also be attached.
What are the consequences if the company ignores the payment or the filing requirement?
The penalties are heavy. €50,000 for the company, and daily fines for the defaulting officers. More severely, if that director's declaration isn't filed within 180 days of incorporation, the registrar may initiate action to remove the company's name from the register. It's a hard deadline.
Can a company fundamentally change its class, such as converting from a public company back to a private company?
Yes, Section 18 permits conversion by altering the MOA and AOA. The registrar handles the administrative closing of the old class registration and issues a new certificate of incorporation.
But does that conversion erase any existing debt?
No, absolutely not. The law is clear. Conversion does not affect any existing debts, liabilities, obligations, or contracts incurred before the conversion. The legal entity is the same, only its classification changes for future operations.
Okay, let's get to our final segment on legal logistics. This is a crucial rule for group structures. Can a subsidiary company own shares in its parent company, the holding company?
Generally, no. Section 19 explicitly prohibits a subsidiary from holding shares in its holding company, and any such transfer is declared void. This prevents complex cross-ownership manipulation.
But there must be exceptions for situations where the subsidiary isn't acting as a strategic investor.
There are three critical exceptions. The subsidiary can hold shares if it holds them as the legal representative of a deceased member, or if it holds the shares specifically as a trustee for a third party. The third exception is if the subsidiary was already a shareholder before it became a subsidiary.
That trustee exception is key. A subsidiary can own shares in its parent if it is merely doing so on behalf of, say, a charitable trust.
Correct. The intent behind the shareholding dictates the legality. Now, the voting rights are handled differently. In the case of the legal representative or the trustee, the subsidiary retains the right to vote. But if the shares were acquired before becoming a subsidiary, those shares are retained but lose all voting rights.
How does the company officially receive notices, and how does it officially communicate with its members?
Documents may be served on a company by registered post, speed post, courier, which must provide proof of delivery or electronic mode at the registered office. Service on the registrar or members is similar. A member can request a specific mode of delivery, provided they pay the cost.
How does the law calculate when service via post is legally deemed complete?
This is vital for meeting deadlines. For a notice of a meeting, service is deemed to have been effected at the expiration of 48 hours after the letter is posted. For any other document, it's deemed served at the time it would be delivered in the ordinary course of post.
So if you need to give 21 clear days notice, you must ensure the posting occurs 23 days prior.
Precisely.
Finally, how does a company officially put its stamp of approval on contracts?
Authentication under Section 21 means documents can be signed by any key managerial personnel or an officer or employee duly authorized by the board.
And for more formal legal deeds, like a partnership agreement?
Formal deeds, covered by Section 22, require a higher level of authority, often through a power of attorney. The authorization must be in writing under the company's common seal, if it has one, or signed by two directors, or are signed by a director and the company secretary. If a director signs a formal partnership deed without that specific written authority, the company can successfully deny liability. So we've successfully navigated the entire legal structure of corporate formation, a meticulous journey from the promoter's initial concept through the layers of constitutional documents and the logistics of legal communication.
Right.
The overall theme is clear. The law provides the protection of limited liability only in exchange for absolute meticulous compliance with these rules.
So what does this all mean for you? We've seen how legal protections vanish if minimum membership requirements or capital payment rules aren't strictly maintained. We've seen how the doctrines of constructive notice and indoor management create a complex balance, protecting outside creditors while also allowing companies to operate efficiently.
Indeed. Understanding these initial sections ensures that the corporate structure, once established, doesn't fall victim to foundational flaws, minimizing the risk of severe penalties, including that ultimate sanction from the NCLT, the stripping away of limited liability.
For you, the key takeaway is the untouchable power of the memorandum. An act considered ultra vires the company is truly void forever. That means the most important decision you make isn't about business strategy, but about defining your company's legal mission on day one.
That leads to our final provocative thought. Given the severity of penalties under Section 447 for fraud at inception and the constant digital stream of data generated by S-Spice plus One Center, How might technology soon allow the registrar to use AI and machine learning to analyze the vast personal and financial declarations to prevent fraudulent incorporation before the certificate of incorporation is even issued? What does a truly conclusive and incorruptible certificate look like in a fully digital world?
Thank you for taking this deep dive with us into the foundation of corporate law.